first would like to introduce, and I'm sure I don't need to introduce, Tracey Holmes, who is generously giving of her time, and all of us in the Essendon group appreciate the independence that Tracey has shown over this period of the Essendon saga. And I think she's been a voice of reason when journalism really, for us, has really let us down, as it lets a lot of people down in Australia these days. But Tracey is stands out there as really one of the great journalists of this era. So I appreciate very much the fact that you're moderating tonight, Tracey.
Thank you.
Okay, I think we'll get started. And so, as I say, we're going to stay fairly closely to the script, the program. If you haven't got a copy, I'll be putting up the slide. The actual symposium is about sports integrity and athletes' rights. This symposium came out of a symposium last year, which was essentially directed at the Essendon problem. The Justice for the 34 group was a diverse group of individuals who were supporters of Essendon, who I think, like many people in the community, fair-minded people, realised that there was a problem in terms of natural fairness directed towards not only the Essendon players but also the coaching staff and supporters. And I think for the Essendon group, I think what was paramount in their thinking was a right to a fair trial, the right of appeal, and the right to prove your innocence. I think that's an understated right in our society. Everyone should have the right to prove their innocence, not only to be able to prove guilt in our society, but to prove you are innocent when indeed you are. And I think the Essendon case showed that the players, in my view, weren't afforded that right. So the purpose of this symposium is to move on. A lot of people would suggest that we're very fatigued by a problem like this, and it went on for 4 years, and now the players are back on the field, and we should move on. But you can only move on in this world if you address the negatives of the past and eventually turn them into positives. And that's the history of our civilisation. If you look at all the great movements of whether it's apartheid or, if you like, the environmental movement and indeed civil rights in general, you do need to address the problems of the past. You need to go back to the mistakes of the past to get the proper framework of the future. And that is partly what this symposium is about, to move to a proper and a better regulatory framework and a fairer regulatory framework for all athletes. There are 4.5 million athletes in organised sport in Australia, according to the ABS. So what we're talking about tonight does impact on all of them in a certain way. We weren't alone in our concerns that the Essendon players were not afforded natural justice. Julian Burnside, a prominent rights lawyer, when James Hird was suspended in August 2013, made this comment. He made it clear right from the start that anything given to the players had to be legal, had to be given the okay by ASADA and WADA, and had to be approved by the club doctor, and had to be given with the informed consent of the players. He reiterated that several times very firmly. And as Julian said there, what more does a bloke have to do? And that was, I think, the sense of a lot of people at the time. But there were many other voices of opinions which were not listened to throughout the saga for some reason. There was a lot of noise. Qualified legal opinion wasn't listened to. Neil Young, a former federal court judge, commented this way on the Court of Arbitration of Sport decision. To conduct a second hearing exposed the players to a form of double jeopardy and offended fundamental principles of justice and fair dealing by giving WADA a powerful appeal right not available to other parties. And Kenneth Hayne, who's a former High Court judge and advocated for the players, and actually is a graduate of the Melbourne Law School, said WADA's right of appeal should have been limited to demonstrating that the AFL tribunal either made an error of law or came to a manifestly unreasonable decision. That's what the relevant rules say, and that is what they mean. I think one of the best expositions of this problem, of our sense of injustice as an Essendon group, was put by Senator-backed Liberal Western Australia at the Senate Estimates meeting on March the 3rd, 2016. And here I have to acknowledge in the audience Senator Madigan, who will be on one of the panels later tonight, and he I think, pushed more heavily than any other senator for some form of redress of the Essendon issue. Senator Mack put it this way: but if 18 or 19-year-old kids were told by the club that the product was safe and they were advised by the club in writing that the product was legal to use, with or without the consent of their parents or other guardians, then I'm at a loss to understand how 34 players are now guilty. I'm also at a loss in terms of proportionality. Even if the case can be made, and I do not believe it can, I'm concerned about the proportionality. We've had a group that said it had been taking it within a 7-day period. We had another group who did not take it within the 7-day period and therefore have been quite honest in saying they did not take it. And we've had a third group who never took it or were never tested. So we really do not know whether they took it. All three groups have been found equally guilty. And as an Australian, I find that unacceptable. And I think that would be a fair assessment of what most fair-minded people would have concluded on the Essendon issue. Last year, when we had a symposium here, a number of issues were identified with the Essendon issue, which I think go to the heart of the problem of the WADA codes and the implementation of them. First of all, there's a lot of inconsistency across cases. Russian athletes, where there is very strong evidence, whistleblowers and as well as documentary evidence, as well as positive tests, have not been penalised. Whereas Essendon were penalised heavily without virtually any analytical evidence. The testing framework is flawed in this problem. The compound for which Essendon were banned, which was thymosin beta-4, is actually endogenous. In other words, it's in the body. And finding a threshold to be able to test whether it's endogenous or whether it's exogenously given is very difficult to determine and probably can never be so determined. It appears the Essendon players were used as an example to deter future athletes from engaging in a supplements program exogenously given. And that is the best, I think, conclusion that any fair-minded person can say, that they were used as an example, scapegoat if you like, but they were used as an example for the future rather than necessarily the penalties of the present. The players themselves, it didn't have just double jeopardy, they had treble jeopardy. They were kicked out of the finals in 2013, they were eliminated from the pre-season competition in 2015 and they were banned for 2016. That doesn't happen in any other jurisdiction. They were subject to a de novo hearing, which means you start again. That doesn't happen. The de novo hearings, if you appeal, which WADA did, you appeal on an error in law in a lower court to a higher court. You don't start again. And that's what happened in the Essendon case. Their rights of appeal were limited to the Swiss Federal Tribunal, and it really wasn't an appeal. It was just the moment they signed up to the process, they didn't have the rights of appeal. In other words, they were not really ever able to prove they were innocent. And what the effect of this was, it took away one of the basic rights of Australians. And we should all be worried about that. Not just this group here, not the people who watch this on YouTube tonight. We should all be worried that we can't prove our innocence. It's one of our most fundamental rights in modern society. We should be always able to prove that we're innocent of an allegation.